The arbitral institution can effectively deal with the obstructing party. They can also liaison between the court and the arbitral tribunal if there is some issues and all that thing, because institution is a legal entity, so it can always act as within the purview of the rules, regulation and the law. But that is the biggest advantage of involving the institution for arbitration. Sawadee krap, everybody, again I'm here again online for the talk, because I'm going to talk on stepwise the due process. So one of the options which the parties can choose is the institutional or ad hoc arbitration. So there are two ways and means of people's choice to do arbitration. So these are actually the procedural rules of arbitration which will govern the conduct of the arbitration, especially in the early stage. When they include the arbitration clause in the contract agreement, they have to decide which one will they choose. And when they have decided that whether arbitration institution or arbitration, because there are a lot of implications thereafter, so they have to make a right choice from the very beginning, depending on their nature of business. So if I may talk about the ad hoc arbitration. So ad hoc arbitration is conducted under rules adopted for a specific arbitration, that particular arbitration, without the involvement of arbitral institute. So here they will not involve the arbitral institute. It is a very separate ways and means of doing the arbitration. So parties here under the ad hoc arbitration, parties draw arbitration rules by themselves usually, generally, but I think, but not sometimes, but generally the trend is that parties will always leave these powers to the arbitrators. They will make arbitrators to draw the due process, and then they will empower them and they will follow that. And sometimes they will also follow the UNCITRAL model rules. They will follow that, or they will give this specific power to the arbitrators to draw these rules of procedure for the arbitration. Most of the time ad hoc arbitration has not been effective as per the research, which is due to the differences and lack of cooperation between the parties. Such problems lead to the delay of arbitral proceeding. I mean to say here that in the ad hoc arbitration, even between the individuals, when they come up with due process or the procedures, when they draw up, there will be so many differences. One will agree, one may not agree. So it takes time for them to really decide into the specific procedures. And even within the arbitrators, I think, when we give certain power to the arbitrators to draw the rules of procedure before the arbitration really begins, it takes a lot of time. And that's why it can also lead to the delay of the arbitral proceedings. So that way the ad hoc arbitrations usually people don't adopt is all because of this reason. But some countries like China, in China they only recognize institutional arbitration. So there is no ad hoc arbitration as such in China. For them it is institutional arbitration. So although use of ad hoc arbitration avoids the need to pay fees to the institution, the preference is usually made to the institutional arbitration, unless parties have no choice but to adopt ad hoc arbitration under certain special conditions of the trade practices. So we know that one of the advantages of adopting the ad hoc arbitration is that we don't have to pay the fees and charges to the institution. But as I said before, usually people always adopt the institutional arbitration unless their nature of business, their nature of business transaction, the nature of the case so demands that it cannot be done through the institution, but it has to be done in a certain special way by adopting or by requesting another neutral body. If that certain case where they cannot use institution, then only they will use the ad hoc arbitration. Otherwise, it is usually the institution which are more viable for the arbitration process. So this is all about the ad hoc arbitration procedure, which is not that popular. And then if I talk about the institution arbitration. So institution arbitration involves incorporating the rules of selected institution in the arbitration clause by reference. So when parties decide that they will refer their dispute for arbitration, and if they want to get involved with the institution, they will specify out which institution. There are so many institutions all over the world. They will choose one institution, and that they will mention in the agreement. We will use this institution. Suppose like if they want to use the like TAI, Thai Arbitration Institution, they'll mention it in their clause or in the agreement, saying that we will use Thai Arbitration Institute. And also they will also say that we will also follow the rules of procedure under TAI. So this is what they will have to do from the very beginning itself. The institution will administer the arbitration proceedings, though real arbitration will be done by the arbitrators appointed by themselves, but the overall monitoring of due process and all will be done by the institution. So once the institution is involved in the arbitration, the institution will design their rules in such a way that it will fit into the dispute. And once the institution gets involved to it, the institution will be there from beginning till the end, till the award is passed. Even sometimes, even the award is passed, institution will get involved into it. So that means the institution will be the overall manager of the arbitral institution. So as I said that the institution rules are better suited actually to cater contingencies that might occur, because we don't know, because sometimes we start with the arbitration and some very unique issues come up, some very the unforeseen things come up. So in that case, the biggest advantage of the institution is that the institution can always adjust to that and always make it very convenient for the parties, so that the arbitration proceeding is not blocked. So these are one of the greatest ways and means of doing through arbitration, through the institution. Then if I may cite certain specific advantages for institutional arbitration. First thing is the availability of pre-established rules and procedures, which ensures that arbitration will get off the ground and proceed to the conclusion at a very faster rate. Because this institution has a pre-established set of rules and regulations already in place, it will ensure the arbitrators and the arbitration proceeding to start off from the ground. You will not be stuck, you will not know from where to start, how to do that. Otherwise in ad hoc, a lot of discussion takes place. So it might take months. But in the institution, we can start away, straight away, because there is a system set already in the institution. So this is one of the biggest advantages for using the institution for arbitration. Other thing is there will be an administrative assistance of the institution which will help in smoothing the proceeding of the arbitration. So since there is a administration set of staffs are there, experts are there who have been dealing with arbitration, they will always facilitate the arbitration proceedings, and that will help both the parties and also the arbitrators. So this is the advantage of involving the institution. Other one is that the institutions will have the qualified arbitrators at their list, in their list of various fields and experiences who will be befitting for the particular arbitration. So based on the nature of the arbitration, the arbitrators, the parties will have a choice to select whichever arbitrator will be befitting for the arbitration. Other one is that, as I have already said before also, there are a lot of like physical facilities and support services for the arbitrators and parties. So you'll have a good sound recording system, good conference hall, lobby, library, so many things that they are attached as a package, and that we can always take advantage of. So these are the extra facilities which institution can always provide for the smooth arbitral proceedings. Then one thing is that because institution by law is also empowered to encourage the reluctant parties to proceed with arbitration. Sometimes you know that the respondent and the claimant, sometimes the claimant may not cooperate during the arbitral proceeding. Sometimes the respondent may not cooperate. So in that case there will be a deadlock and arbitration proceeding may not go. So if you engage the institution has certain power to make that party to cooperate, to respond, and to go and to follow the arbitration proceeding. So these are the added values for choosing the institution for the arbitral proceedings. And the other thing is that the institution has the established format. There are forms and all that things are there. So for like forms for submitting the response, for also then the form for the witnesses and form for the arbitrators. So many forms are already there established, and people can straight away use that form, and then you know that will also add up to for saving the time and the cost. So that's why I always say that the arbitral institution can effectively deal with the obstructing party, and also sometimes they can also then they can also liaison between the court and the arbitral tribunal if there is some issues and all that thing, because institution is a legal entity, so it can always act as within the purview of the rules, regulation and the law. So that is the biggest advantage of involving the institution for arbitration. Of course, like if you involve institution, there will be certain fees that are applicable, because ultimately because the institution is also using its resources, the staffs, everything. So for that there will be certain fees, and that fees will be fixed sometimes either based on the amount involved in the arbitration, or it could also depend on the amount of time spent for the arbitration. And the fees for the arbitrators will also be fixed, and that will be already announced beforehand, and parties can always see to this fee structure and see whether they can afford or not. So these are the advantages of involving institutional arbitration, and with this I would like to end my talk here and wish that you all will be encouraged, and we are also going to set up the online arbitration very soon. For that also we have the technology and experts here, so looking forward to see you either online or in live on the ground. We'll see. Thank you so much.